The first step is definitely preventing errors. EB-5 is a very niche space, and so it's constantly evolving. The interpretations that the agency used under President Obama are different than the interpretations used under President Trump, which is a lot different under President Biden, and now again with Trump, right? So if someone's been in the industry long enough, we are able to track all the interpretations, look at all the RFEs, and then our combined knowledge, we're then able to apply that. So at least as of today, our firm has gone back to the standard we were using under Trump, right? We're very careful. We make sure that we cite everything that we're writing. We make sure every statement has a corresponding exhibit. The standard has changed significantly. Under Biden, they were approving anything and everything. Under Trump, they were applying policy. They were asking questions, and we expect that to return. So it's very important that the application is crafted properly and you don't have any lethal errors. There's nothing in the law that mandates USCIS to respond to an RFE with the next number of days, right? So it's not that we submit an RFE and then USCIS has 60 days to respond. What happens is once you respond, they have unlimited time to look at it. They may forget about it. They may push it at a desk. And why is that important for Indian nationals? We saw in December that there was a warning shot fired by the Department of State stating that India might retrogress. In these cases, if we have clients that are outright approved, the government can move on and work on the 485 application, which is the application for conditional green card. However, if the petition wasn't filed properly and you've now ended up with a request for evidence, you are not getting a green card anytime soon. You're going to submit a response. You're going to wait 6 to 8 months. By that time, India will have retrogressed. And if your date is not current at the time of approval, there's no chance that the government's going to issue you a conditional green card. It could result in years of you waiting for the date to then move forward again. So I believe in filing a perfect petition just on step one. We just had an RFE. Hate saying it, but the RFE stated, thank you for submitting your documentation. However, it seems like Exhibit 22 to 44 was lost. That is a USCIS error. The way EB-5 works is we ship a petition to Texas. Texas is a contractor. Texas pulls apart files, ships the I-526E petition to DC, which is where the IPO is, the Immigrant Program Office, Investor Program Office. In that process of shipping, files get lost. Some documents get lost. That is a USCIS error. At least with our firm, we've seen a two-step approach. We've seen an RFE, and because we're very diligent, we're very quick, we have electronic copies of the RFE, we're now able to extract those exhibits 22 to 44, upload it to the government's portal, which is your USCIS account, and get approvals within 24 to 48 hours. So it's not like we're waiting, printing the file, shipping it. No, we're using technology where the government provides it to us, and we have an electronic copy of the file available. So we're not going to reinvent the wheel. We know there are a bunch of firms that are doing paper filings. We do paper filings as well. However, we also have an electronic copy available, right? That is not an error on my part. That is not an error on the investor's part. That is just merely a shipping problem, a logistics issue, and that happens more than you'd like. If the dates were to retrogress, if the table was to say April 1st, 2024, you can still file your 526E petition, but what you cannot file is your application for green card. And if you cannot file your application for green card, you then don't have the ability to file for a work permit and travel permit, which is the biggest draw for EB-5 today for H-1B, TN, F-1 visa holders residing in the United States. They want that work permit. They want that travel permit. So we encourage our clients to file in January or the first half of February and not wait until the end of February. What we've been seeing is due to the stock market correction, we've been seeing clients wanting to wait. Clients become complacent. Hey, February was current, so maybe there's chance that March will be current, right? We have no way of knowing that. And to just give yourself some room and your attorney some room for administrative errors, you want to file in the first half of February. If you were to file in the end of February and the file gets kicked back due to administrative error, and you're working with someone who, say, does 2 files a year, they're not going to know what to do in order to retain your priority date, which is going to cause a lot of anxiety for the client. And if you lose that priority date and you have to refile in March, you can only refile your 526E petition, not your 485, not your application for work permit, and not your application for travel permit. Yeah, so as Sandra said, EB-5 is busier than it's ever been, even busier than 2019 when the amount was increasing from 500,000 to 900,000. USCIS sometimes fails to send notices. We just had a recent experience where they did issue a preliminary notice but never issued a proper notice with a case number, or it's sent to the wrong address, in which case your attorney or you need to know that there are online tools where you can request a copy of the receipt, re-request a copy of the receipt. It is important to follow up quickly because sometimes regional centers are not able to release the funds from the escrow until the 526E receipt is provided to them. The longer it takes for you to release the funds, the longer it is taking for your capital to be at risk. So extremely important to follow up. If you see your check cashed and if you do not see a receipt in hand within 14 days, you need to follow up with your attorney to see what's going on. And you need to request a new receipt notice through USCIS tools that are available online. You also need to log into your USCIS account frequently, spot any missing notifications. What we ask our clients to do is enable email alerts. So what that does is anytime there's any update to our USCIS account, you automatically get an email. Make sure to keep current with your emails. Make sure to log into your USCIS account regularly. We also, in our first consult, tell our clients that on December 2nd, 2024, the adjustment of status guidelines changed. We no longer can file adjustment of status without a medical report. If you're planning to file your EB-5 application, make sure you go to USCIS physician locator, contact a doctor close to you, get your medical done. With a lot of Indian clients, we see that they test false positive for tuberculosis. That could make it very difficult to get a report in under 3 weeks. If you're missing vaccines, you need to go through multiple doses of MMR. You're not going to get that report. Again, we warn our clients when we do our first consult, if you're going to do EB-5, call a doctor, get that medical report done.